Hello everyone, welcome to our webinar on mediation as the ideal ADR mechanism for Fintech. Speaking today are Mrs. Franca Ciambella, a mediator with many years of experience and practice and Managing Director of our Consilium Law Corporation, Ms. Chiara Conero, representative for WIPO Arbitration and Mediation Center, and Mr. Adrian Fisher, who is today representing the Singapore Fintech Association. During the presentations, you may type any questions you have into the QA box that you can find at the bottom of your screen, and you may also promote any questions you would particularly like to hear answered. I'll put the questions to the panel after the presentations. We will be recording this session and posting it on our website and Facebook page for your future reference. So now, without further ado, I will hand over to Franca, who will speak about the process and benefits of mediation as a tool for dispute resolution. Thank you, Franca.
Okay, thank you very much, Catherine, for the introduction. My name is Franca Ciambella, and I'm the Managing Director of Consilium Law Corporation. That means I'm a lawyer, but I'm also a mediator. And I mediate in various organizations. I'm pleased to be on the WIPO panel of neutrals. And Chiara will talk to you a little bit more about that later. I'm also a member of the Singapore Mediation Center and the ADR group in London. And before I start, I'd like to say thank you to Catherine and to Margaret from Consilium Law for having put all of this together. And I'd also like to thank my co-speakers, Chiara and Adrian, and their organizations for being here today. But mostly, ladies and gentlemen, I'd like to thank you for taking time out of your busy schedules to join us for this presentation on mediation as the ideal ADR mechanism for Fintech. Just very quickly, these are Consilium Law's areas of practice, and as you'll see, there's mediation, which means I do private mediations from my law firm, and we also practice in the areas of Fintech and regulatory and compliance. And here is the disclaimer, which basically says I'm going to be giving you some information on mediation, and none of what I say is supposed to be construed as legal advice. So what are we going to cover today? Well, we're going to look at what is mediation. We're going to talk about some disputes in Fintech and some that I've seen and mediated myself. We're going to talk about the benefits of mediation generally. We'll also talk about the advantages of mediation specifically for Fintech, for the Fintech sector. I'm going to tell you a little bit about the process of mediation, i.e. how it happens. And then I'll say something on the very important Singapore Convention on Mediation. And I'll close off by talking a little bit about mediation and how we've been mediating during this COVID-19 period. So I'd like to draw your attention to this very first slide, which is a very important slide because it talks about where mediation is in the spectrum of possible mechanisms to resolve your dispute. And you'll see on the left-hand side, we have mediation, which is the most cooperative form of resolving a dispute. And when you go through the spectrum, past conciliation, arbitration, and then finally litigation, which is the most adversarial and non-cooperative way of resolving a dispute. Now, mediation is the most cooperative because it really relies on the parties coming together and arriving at a solution themselves. Whereas in conciliation, we don't have a mediator, we have a conciliator, and the conciliator actually makes suggestions and tries to resolve the issue for the parties. And then many of you are familiar with arbitration, and that's basically like a litigation, except it's privately held. And instead of a judge, you have an arbitrator who renders an arbitral award instead of a judgment. And then in litigation, of course, we all know that's when you go to court and the parties have their own lawyers and there's a judge who renders a judgment. And litigation is more public than any of these others. These others are very confidential, but litigation is public information. Okay, so what is mediation? I know many of you aren't really familiar with it. So mediation is a process where a third party neutral i.e. the mediator, acts as a facilitator to assist parties in resolving a dispute. So what's key here is that the parties are actually going to resolve the dispute themselves. Mediation should be voluntary, meaning that the parties have to be willing to come and try to resolve the issue. If you force somebody to do mediation, often whatever agreement they reach, they're not going to comply with because they were forced to do it and really didn't want to do it. It's non-binding, which means that the process of mediation doesn't bind you to any agreement unless you sign an amicable agreement at the end. So the actual process itself is non-binding. And then it is without prejudice, which means anything you say during the process won't be held against you if in the event you don't settle and then you have to go to court. And so in a mediation, the parties attend in person or virtually, and these days we're doing a lot of them virtually, before a specially trained third-party intervener, who we call the mediator, whose job it is to manage the process and assist the parties to come to a resolution. Now, disputes in the fintech sector, they're in many areas, and I've listed just a few here. You know, they're with licensing agreements, they're with developing agreements, they're with maintenance agreements, they're with payment terms, there are terms and conditions, then there are infringements of IP, ownership, compensation between parties, you name it, disputes can happen in the fintech area. And who do they happen amongst? Well, see a lot between co-founders, advisors, investors, and in the investor sector, we see some with collective investors or a number of investors coming together, third-party service providers, users, participants, a whole slew of parties can be involved in disputes. Now, generally, what are the benefits of mediation? Well, mediation saves time and costs because the process can be completed just in a matter of days. And typically, the mediation itself will last a day. In fact, 99% of the ones that I've done have been just one day. And we try to get them done in a day because we feel that if the parties go home and they mull over what happened during the mediation, they'll come back the next day and they'll change their minds. But however, if the parties need more than one day, then we'll allocate the time and we'll basically give the parties as much time as they need to complete their mediation. There are faster results than in litigation. You don't spend any time waiting for a judgment because you've resolved the issue during the mediation itself on that very day. And then legal costs are kept to a minimum as cases are settled quickly and with less involvement of lawyers. So that's a general benefit of mediation. Mediation also makes the party feel autonomous and empowered because, as I said earlier, it's the parties themselves that come to the resolution. The mediator helps manage the process, but it's a solution that's created by the parties themselves. And because of that, there's a high rate of compliance of mediated settlement agreements. And the parties, of course, have more control over the outcome. One of the biggest complaints I hear is, I've had a working relationship with this party for a long time. The judge doesn't understand the whole thing. How can the judge decide in just reading the brief over a matter of hours and decide the whole thing? Well, in mediation, the parties decide themselves, and who's in a better position to know the situation than the parties themselves? There's a lot of flexibility in mediation. As I said earlier, it's a voluntary process, so the parties have to be willing to come. It's without prejudice. It's totally confidential. Okay, and apart from rules on not interrupting the other party when they speak, being courteous, no name calling and things like that, there are no formal rules and procedures. And you have the freedom to speak out. So I tell parties, this is your mediation, we're here for you. So you tell me what works for you. We have a general format that we follow, but if you need to take a break or, you want to stop for a while or, you're hungry and you want a tea break or something, we can do all of that for you. So it's less rules and procedure. And mediations can easily be conducted virtually via conference videos or telephone calls, and to accommodate parties who can't come together because of COVID or because they're in different jurisdictions, and also counsel who may not be in the same city, and also to accommodate time zones. So I've done mediations from all over the world, and sometimes we have multiple time zones, and we do them by video conference. The only thing I can say is be prepared to stay up in the middle of the night, especially with different time zones. Mediations are also a lot less stressful than going to court because, as I said, there's less of a procedure, less hostility, and an informal environment. In fact, I encourage the parties to come casually dressed and to feel more relaxed and less stressed. Now, in particular for fintech disputes, why is mediation really good? Well, as many of you know, litigation can attract a lot of unwanted publicity. And that's the biggest fear I hear from, or one of the biggest fears is, I don't want this litigation to get out, or if my investors hear about this, or I'm trying to pitch for investment and I can't have any litigation because they're going to run away. So of course, litigation can affect performance, confidence, and market value. Litigation also takes up time that could otherwise be spent on development and commercialization. And most of the fintech clients that we have are very lean and mean, and they don't want to take up their time, preparing for litigation, whereas they could be doing something more constructive, like improving their product or commercializing their products. And then, of course, litigation is costly. And again, many of the fintech clients, or many fintech parties, are very lean. In other words, they don't have a lot of people. Sorry, I'm talking about litigation being costly. They're also very, very cost conscious. So a lot of the fintech parties, many of them are startups, and they're very cost conscious on how much the litigation is going to cost them. So mediation is a lot less, so that's what makes it a lot more attractive. Mediation is increasingly used in international and domestic commercial practice as an alternative to litigation. And Chiara is going to talk about WIPO shortly, but there was a survey done that found that most of the respondents said that some sort of negotiation or some sort of ADR clause was negotiated in their contracts. And so the most commonly used dispute resolution clauses were, of course, litigation is still the most popular, but not by much. Arbitration was second, and mediation third. So clearly, we have a long way to go to inform parties about mediation and the benefits of mediation, because it's not as commonly used as the others. But however, the good news is that according to this WIPO survey, 70% of mediations administered by WIPO have resulted in settlement by the parties. And I have to say that in the mediations I've done, almost all of them, way over 90%, were resolved. And that could also be because I tell the parties that I'm going to keep them and I won't let them go until we've finished. So even if it goes on to midnight, so maybe the fear of being stuck with me mediating all night, pressures them into coming up with some resolution. Of course, I'm joking here, but all that's to say that the results with mediation are very good. Some examples of disputes in fintech, some real examples, and this one is a WIPO mediation. Was an actual case, and it was between a German licensor and some European and US licensees. And so the licensees accused the licensor of infringing and not complying with the agreement. There was a dispute clause in their contract nominating WIPO mediation, and the parties commenced the mediation and they were able to reach a settlement. I have a few examples from my own personal mediation practice. And one of them, the first one, it involved a company that had contracted with another company to develop a product for them. And so, as we know, products are constantly evolving, and often you find better improved products quite quickly elsewhere. And that's what happened. So they found another company that was actually manufacturing a similar product, but it was superior. So they tried to get out of the contract with the original company they had contracted with. They came for mediation, and what ended up happening, and it was really a surprise ending, is that the company that had engaged them to develop the product actually ended up buying them out. And they decided that they would develop the most superior product in-house, working together. So that was a really surprise twist in the mediation. And that can happen in a mediation because the parties are free to speak and to really talk about what they want to do. The other one that I want to talk about is when intellectual property rights come into dispute. This dispute typically arises when the contract between two companies come to an end, and one of the companies seeks to use the intellectual property in a different project or share it with a different company. And in fact, this one didn't involve two companies. It actually involved an employee and a company. And we see this dispute over ownership of IP rights often in an employer-employee situation. And so what ended up happening here is that the company paid the employee of the other company for the IP rights, and then they were transferred over to it. The third example, and this one I see a lot of, maybe too much, and it's between co-founders, disputes between co-founders, and disputes between advisors and founders over compensation. And in one very big one between two co-founders, their dispute was really over the direction of the platform, or over the direction of where they wanted the business to go. And what happened there is one co-founder bought out the other one. And in the dispute between the advisors and founders, we ended up coming to a very fair compensation for the advisors. And in that one, they didn't want to be paid by way of tokens. They wanted cash, and we ended up having a combination of cash and tokens. And the parties left very, very satisfied and thinking it was a very fair settlement. So those are some examples of mediations that I've been involved with. Guess now I want to talk to you a little bit about the process of mediation, how it works. And as I've said before, it is a voluntary process. Lawyers may attend the mediation, or you may come without a lawyer but have the ability to consult a lawyer. And some parties don't want to even consult with a lawyer, but what they want to do is get legal advice before they come to a mediation, and then they feel confident enough to be able to do the mediation on their own. This is a question I get asked all the time about lawyers attending. The thing to remember is mediation isn't about law. It isn't about applying the law to the problem. It's about parties coming to a solution that they're happy with. So in many ways, while it's good to know your legal rights, that needn't direct how you're going to resolve the issue. You can resolve it in any way that the parties agree to resolve it. Okay, what happens during the process of mediation? And I've separated it into three parts: the appointment of the mediator, secondly, the pre-mediation stage, and thirdly, the mediation session. This structure or this process can vary depending on the organization that's doing the mediation, or depending on the mediator, and depending on the needs of the parties. I think the appointment of the mediator is a very, very important step. And in organizations like WIPO, they often have panels of mediators that you can choose from. And what I think is important is that the mediator you choose is neutral. Not only do they are they neutral by fact, but they also act as though they're neutral, and you don't feel like they're favoring one party over the other. And so it's important that a mediator be neutral, and if they're conflicted in any way because they've worked with one party or they're familiar with a party, they need to disclose it immediately and recuse themselves from acting as a mediator. Parties need to feel comfortable speaking in front of the mediator, and sometimes they're feel embarrassed because they may have done something they shouldn't have done. So it's also important for a mediator to assure them that they're not going to be judged, and that the mediation is a safe environment where you can talk about anything you'd like to talk about. The pre-mediation stage, and as I said earlier, not all mediators have a pre-mediation stage. I usually do because I find it to be very useful. And what I do during a pre-mediation stage is I meet with each of the parties individually, and I try to understand what's important for them, what aspect of the conflict is really bothering them the most, and what's important for them in terms of a result. I don't discuss the mediation with them. I just try to understand what the problem is. And by doing that, it helps me to guide the mediation in a better way. And at that stage, I also make a rough list of agenda items that are going to be discussed. And of course, that can change during the mediation. Parties can have other things they want to discuss. And we also set a date and time for the mediation. So I tend to do that at the pre-mediation stage. Then the mediation stage itself, as I said earlier, we usually try to complete it in one full day. The parties come together before a mediator, but these days we're also doing it virtually. So it's by video conference or even by telephone. We try to have constructive and amicable approaches to resolve the dispute. The mediator leads and guides the parties through the process. So as I said earlier, the mediator doesn't decide anything and doesn't advise the parties. The mediator is there to guide and manage the process. The whole process is confidential, is without prejudice. So it means that during the process, you can say anything you want and it won't be used later on. And during the process of mediation, the parties are reminded to be respectful of one another, courteous, and not to interrupt each other while they're speaking. Everyone is assured that they'll get a chance to speak. So what happens in the mediation? Well, the parties come together and each of them make their opening statements. In other words, the opening statements is they're telling their story in their own words and what is really what the problem is in their own words. And then after each of the parties have had a chance to do that, we discuss what we call the concerns and interests, which we look at what the parties have said and we said, okay, so it seems to me what you're saying is you're bothered by this, or this seems to be the issue. And then often what we'll do is we'll separate the parties and we'll speak to them separately and confidentially, and that's what we call the private caucus sessions. Once we've done the private caucus sessions, we may bring the parties together again to speak, or we as mediators may sum up where we see the agreements so far and what needs to be worked on a little bit more. And as each agreement or as each conclusion arises, we'll put it in the form of an agreement. So if the lawyers are present, they can start drawing up the agreement. If not, the mediator helps the parties draw up the agreement right then and there. And at that point, if there are no lawyers present, if the parties want to take the time to email it to their lawyers and have the lawyers look at it, they have the opportunity to do so. Now, I've said all along that mediation is non-binding and on a without prejudice basis. That's the mediation process. But once you have an agreement and you sign that agreement has the force of a private contract and is legally binding and enforceable. Okay, so which brings me to the Singapore Convention on Mediation. And this is a very important convention. because it aims to address the lack of a process by which settlement agreements can easily be recognized and enforced internationally. Currently, settlement agreements have the status of contracts. As I said to you, once you sign the settlement agreement, it's a private contract. And if one party doesn't comply with it, then you have to go through court proceedings. What the Singapore Convention does is if the parties are in countries that have signed the convention, then there's an automatic recognition of that settlement agreement and you go straight to enforcement. Now, many of you may have heard of the New York Convention, which aims to enforce arbitral awards. So the Singapore Convention is the equivalent of the New York Convention, except for mediation, or except for settlement agreements that arise out of mediations. And again, as I said, the Singapore Convention establishes a framework for international settlement agreements resulting from mediation that is acceptable to states with different legal, social, and economic systems, contributing to the development of harmonious international economic relations. So that's really the aim of the convention. And it's called the Singapore Convention because it was signed in Singapore on the 7th of August last year, and it will enter into force on September 12th, 2020. So this September it will enter into force for the countries that are signatories. And so far, there are 52 signatories. And you'll see on this list, big countries like China is there, India is there, the United States is there. So a lot of the larger countries have signed on to the Singapore Convention. Now, does the convention apply to fintech or disputes in fintech? It doesn't apply to certain disputes like employment disputes or disputes pertaining to matrimonial law, but it applies to international commercial disputes. So to be considered international, at least two parties to the settlement agreement have to have their places of business in different states. And they also, or they can have elements of the contract that are substantial in different states, or that the obligations under the settlement agreement have to be complied with in different countries. So you need that element of different countries in there. And so for a dispute in the fintech sector to fall under the Singapore Convention, it has to be more than one country, and it's a commercial dispute. Okay. In order for the agreements to be recognized, they must have been concluded after the convention entered into force for that state. They must resolve for mediation, and they must be concluded in writing, although you can have them electronically. Okay, what do you need to do in order to have your agreement enforced under the convention? Okay, so the settlement agreement has to be signed by the parties, and there has to be some evidence that the settlement agreement arose from mediation. For example, getting the mediator's signature on the settlement agreement. What I typically do is I put my stamp on it that also has my address and contact details. You can also get a document, a separate document from the mediator stating that a mediation was carried out and giving the details. Or the institution or the organization under which you're doing the mediation can also give evidence, or any other evidence that serves to show that a mediation was held and the settlement agreement came out of that mediation. So some of the things to also, consider with the Singapore Convention. So the Singapore Convention doesn't tell you how mediations are supposed to occur. It doesn't say you need to have a pre-mediation stage or you need to do this and that. It doesn't say that at all. It just says that a mediation has to have occurred. And it also doesn't tell you how the settlement agreements are to be enforced. So each party to the convention has to enforce the settlement agreements in accordance with the rules of procedure in their country. Okay, And if in the settlement agreement for mediation, you agree to something that's illegal in a country, well, then obviously you can't go to the courts of that country to have it enforced because it's illegal. Okay, and the burden is on the parties to self-monitor compliance. Now, regarding Singapore and the enforcement of settlement agreements under the Singapore Convention, in February 2020, the Singapore Parliament passed the Singapore Convention on Mediation Act, which gives effect to the Singapore Convention. And so therefore, a party to an international settlement agreement may apply to the High Court to record the agreement. Or if you need to enforce it, you can apply to either the High Court or the Court of Appeal to enforce the settlement agreement. I'm going to end my presentation to talk a little bit about mediation in COVID-19. So all over the world during this period of the pandemic, courts have either closed or have slowed down and have only dealt with emergency cases all over the world to help curb the spread of the virus. And of course, this has caused delays in legal proceedings. And we've also seen closures and slowdowns with respect to arbitration and of course, mediation. And in fact, certain organizations during the circuit breaker period here in Singapore stopped mediation altogether. But it's picked up now, and mediation has continued, but through the use of video conference, Zoom or WebEx, or by telephone conference call, and in certain cases even in person, of course observing the physical or social distancing rules. I've had the opportunity to do mediations by both Zoom and by telephone conference calls, and I have to say I have found it difficult. I found it difficult for various reasons. Firstly, you have to have a little bit of knowledge of technology, for example, how to have parties step in and out so you can have your private caucus. I've also found that when you do it by video conference, the parties have asked that they do parts of the mediation and then pick it up later on, or that one party does their part of the mediation first without the other party. And so it's been a little bit not as well organized, but it has been doable. And in the cases where I've done it, we have reached a settlement. But it's taken a little bit more time. I've also found that some of the parties were not as comfortable speaking over video conference or over the phone. So it took a little longer to make them feel at ease because they weren't used to it. And then there was also fatigue of being before a screen for continuous hours. So we've had to take breaks and then keep coming back, which resulted in longer periods for the mediation. But it's been doable, and it's something that we'll probably get used to doing more and more of, and it should not stop us from doing mediations. So that comes to the end of my presentations. I'd like to thank you very much, and I'll be around to answer questions afterwards. And I'd now like to pass it on to Chiara. Thank you very much.
Thank you very much, Franca. I hope you can all hear me well and eventually also see my slides, which I am uploading. Voila. Well, good afternoon or morning or even evening, everyone. My name is Chiara Cornero, and I am the representative of the WIPO Arbitration and Mediation Center in Singapore, where I'm based. So Franca has explained what is mediation, how a mediation runs, the benefits of mediation, and also has shared some of her practical experience with mediation. What I would like to do now in the next few minutes is to share how WIPO, the World Intellectual Property Organization, may help you resolve your fintech disputes using mediation. So first things first, what is WIPO? What does WIPO do? So WIPO stands for the World Intellectual Property Organization, and it is an agency of the United Nations. It is an agency which is specialized in intellectual property. And the mandate of WIPO is to promote innovation and creativity for the development of all countries through a balanced and effective IP system. So in practice, we provide intellectual property services which should encourage individuals, but also businesses to innovate and create. So maybe some of you may already be familiar with some of the WIPO services, for example, for the international registration of patents, of designs, of trademarks. Now, another service which the WIPO offers is the alternative dispute resolution. So resolving disputes through ADR, so for example, mediation as an alternative to court litigation. And this is what we do at the WIPO Arbitration and Mediation Center. Basically, our purpose, our aim is to reduce the impact that disputes have on innovation and businesses. And we really focus on prioritizing time and cost efficiency. And also something that we try to do, especially with mediation, is to help parties preserving their business relationship. So, one thing which is very important to keep in mind is that at the WIPO Center, we do not function as a court. So we do not decide the cases ourselves. We do not mediate any case ourselves. We have a number of arbitrators, mediators, such as Franca, that does that. What we do is we facilitate the resolution of disputes. And we're going to see exactly what that means. And when we talk about disputes, we're talking about commercial disputes between private parties. Most of them are intellectual property and technology related disputes. Now, we have offices in Geneva and Singapore, but to use WIPO mediation arbitration, you of course don't need to go all the way to Geneva or to come to Singapore. Our mediation and ADR services have been used from parties based everywhere in the world. So for example, a mediation can take place anywhere in the world where the parties are. Also, of course, through online tools that we've seen quite often lately. And there are a couple of features which I think are very specific to the WIPO Center. One of them is that because we are part of the World Intellectual Property Organization, we are neutral. So this means that we have no connection, no link with any specific jurisdiction, country, language, or law. And this is actually something that could be quite useful if you are ever dealing with an international dispute, so where there are parties from different countries. Because say that, for example, you are from Singapore and you have a dispute with a party from the United States, the other party may have an interest in going to the US courts, but you may not share the same interest. So having a neutral forum, such as the WIPO Center can be an advantage because it's more acceptable to both parties. Now, another feature of the WIPO Center is that, again, because we are part of WIPO, we specialize. So we specialize in intellectual property and technology, and this includes fintech as well. So, for example, we have developed a network, a list of experts in all fields of intellectual property and technology, also including in fintech. And this is quite important because sometimes in intellectual property and technology disputes, the issue at stake may be quite technical, or in any case, it may be an advantage to actually have as mediator or arbitrator someone that understands the industry, the business in which you have a dispute. Also, being the WIPO Center not-for-profit, our fees are as low as they can be, and that's also because many of the disputes that we see, especially in the area of fintech, actually involve startups as well. So sometimes there are some cost consideration. So we always try to also tailor the procedure, its fees, also negotiating the fees of the mediator or the arbitrator to the specific dispute. And we do offer different ADR services, for example, arbitration, expert determination, domain names, dispute resolution, but today we're focusing more on mediation. So basically, what do we do? I've already mentioned that we do not mediate the case ourselves at the center, but we facilitate this. So this means that even before a case is submitted to the WIPO Center, we provide procedural assistance. So procedural assistance means that, for example, if you are drafting a contract and you are including a dispute resolution clause, we can advise you on that. So we can give you procedural advice, we can help you drafting the clause you're going to include in your contract. Or for example, if you are involved in a dispute, we can also give you some procedural advice on what could be the possible procedure to resolve that dispute. Then, once a case is actually submitted to the WIPO Center, we administer the case. So basically, what we do is we make sure that the case is on track. So we facilitate the communications between the parties. We also help parties, for example, find meeting rooms for the mediation sessions. We take care of the financial aspects. So one thing that I find particularly useful, because it may be a bit sensitive, is we help the parties negotiating the fees of the mediator or the arbitrator, also depending on the type of dispute, on the amount in dispute. And what I think is maybe the most useful thing that we do during the case administration is that we assist parties selecting and appointing their mediator or arbitrator. So as I mentioned, we do have a network, we do have a list of mediators, arbitrator, experts that can be appointed in these cases. And really they are based everywhere in the world, speak different languages, have different expertise, not only in the specific legal field, so say patent law or copyright, but also in the industry field. So sometimes also having as mediator someone that has an understanding of the industry, say your Fintech, is also an advantage. And the reason why I think it's really crucial is that, especially mediation, Franca said this, it's absolutely vital that the parties trust the mediator. So it's really the quality of the mediator that makes the quality of the mediation. And when we appoint a mediator, we don't just select one ourselves, but we try to get as much feedback as we can from the parties. So really seek the maximum party involvement. Of course, we've also seen a few online mediations nowadays. We do have some online tools. So for example, one is WIPO EADR. WIPO EADR is basically an online platform where all documents can be uploaded and downloaded in all cases, and of course it's secure, it's confidential. But also we have video conferencing services that we offer in our cases, and it's quite useful there because of course the IT part is taken care of by us, and in our experience that worked quite well. So all the mediations that we have seen held online were settled in the end. It's true what Franca mentioned, that sometimes the mediator had to actually schedule breaks because it may be quite tiring to be in front of a screen for the full day, but at the same time, the flexibility of mediation and really of using video conferencing or even the telephone really allows you to have breaks and to really structure the mediation as you like. Now, I mentioned that we give procedural assistance, so we help parties drafting clauses, for example, and this is because mediation is a consensual procedure. So it means that both parties need to be on board, need to have consented to submit their dispute to WIPO mediation. How can they do that? So the first way, let's say, is to include a contract clause electing WIPO mediation. and they can do so in a dispute resolution clause in their contract at the beginning of their collaboration. And for these, we also provide for model clauses that are available in all languages on our website, and they're really free for the parties to use, and also to even edit and change and tailor a little bit. For example, this is one of the clauses that we see being used the most, which is a WIPO mediation clause followed by WIPO expedited arbitration. So what we can do, for example, when you're drafting a clause, you can select and draft your clause, and then you can, for example, send it to us and contact us, and we can help you to check if the clause is workable. In general, we do suggest using model clauses because those have been developed by experts and are workable contract clauses. But for example, imagine the case that you don't have a contract or a collaboration with the other party, or maybe you do have a contract, but there is no mediation clause. You can still select and submit your dispute to WIPO mediation, and it's very simple. You can also do so unilaterally. So we have, for example, this form, which we call the unilateral request for WIPO mediation, with which one party can unilaterally request mediation to WIPO. And as you can see, it's a very simple form. It's a one-page document where basically the initiating party has to provide some general information on itself, on the other party, on the dispute. And then the next step is that that's sent to us, to WIPO, and then we actually get in touch with the other party to try and seek their consent to submit the dispute to WIPO mediation. Of course, for the mediation to start, the other party also has to agree to sign the document. And again, it's important because mediation is consensual, and in any event, for mediation to be successful, it takes both parties to sort of be on board. Now, in the area of fintech, we have actually seen quite a few cases. And that's why, for example, we have a specific web page which explains a little bit our work in the area of fintech. So, for example, we collaborate with fintech associations. One of them is the Singapore Fintech Association. Adrian is going to say a few words about the association later on. So, for example, under the collaboration that we have with the association, there are some reductions for the members of the association. We also collaborate with other associations. We will provide training. We also have identified some mediators that have some specific expertise in the area of fintech. So, for example, all those experts could also be appointed as mediators. And this is really just an overview, which Frank already mentioned on some of the cases that we have seen in the area of fintech. And really, the takeaway from this is that there is such a diversity and big variety of disputes in terms of the subject matter, which really ranges from IP, IT licensing to performance, but also for the parties which are involved in this kind of disputes. So it's yes, banks, IT companies, but also startups, online marketplaces is something that we've seen quite increasingly. And really what we try to do is to treat each case differently, to tailor really the procedure, and that's something that mediation allows to the specific case, to the specific parties, to the specific needs of the parties. And this is the last point I want to make. So this is our caseload, our ADR caseload. But I would like to actually focus on the 70% settlement rate that Frank already mentioned before. This means that in 70% of our cases, the parties do manage to find a settlement. But actually what happens in the 70% of cases is that the parties, most of the times, they do not just resolve the dispute, which is already a success, but very often because of the nature of mediation also allows, which is very collaborative, also allows the parties to continue their business relationship. And this is because really mediation is not based on the law and the parties' legal rights, but is usually based, and the result of the mediation is really based on the parties' business interests. So this allows for the parties to tailor a solution to their business interests, and in many cases we have seen that the parties were able to continue the collaboration, even in some cases to expand the collaboration. And even in arbitration, we haven't said much about arbitration, but basically in arbitration, there is a decision from the arbitrator, so it's very different from mediation. And that's quite, in a way, surprising, because usually when one starts arbitration, it's not looking for a settlement. It's mostly looking for a favorable decision from the arbitrator. But even then, in 30% of our cases, even in arbitration, parties manage to find a settlement. So this is really to say that there is plenty of room for settlement, both in mediation and even in arbitration. And especially for fintech disputes, there are some characteristics of mediation, such as the time and cost efficiency, the possibility of choosing your own mediator, of tailoring the process to your needs, especially the confidentiality that one could at least consider when dealing with some fintech disputes. So this would be it for WIPO ADR. Of course, I'm more than happy to take any questions at the end of the webinar. And I think it is now, I'll leave the floor to Adrian to introduce the work and the activities of the association.
Great. Thanks, thanks, Chiara, and thanks, Franca. So I'm here as a representative of the Singapore Fintech Association. My name's Adrian Fisher, and I sit on the committee of the association. And really, I'm just tacking on to the end here to give you just an overview of what the association is for those of you who aren't aware, and also a bit of an update on some of the funds and grants that we are helping to administer to our fintech members, given the current COVID-19 situation. So for those who aren't aware, the Fintech Association is a not-for-profit member-based organization, and we've been around now for the last 4 years. And our objective is really to create an ecosystem for the fintech community in Singapore, and we do that through a number of means. We now have over 500 members, and those members are both very small startups to scale-ups to emerging tech companies, and also in incumbents. So we have a lot of financial institutions, insurance companies, tech companies, etc., who are members. So we have a very wide-ranging membership base, and our aims are really to bring people together, to form partnerships like the one we've got with WIPO, which Chiara mentioned, to bring people together to talk about topical issues, to ensure that there is access to education, lead generation for companies looking for fundraising. So a whole bunch of activities. You can find out more on our website, singaporefintech.org. And if you aren't a member, but you are a fintech in Singapore or with connections to Singapore, we'd obviously love to have you with our membership. Just so you can see some of the stuff that we're doing, and particularly, I guess, what is quite topical at the moment, I did want to share about the government grants that we are involved in administering at the moment. So, some of you may be aware, but in Singapore, there is when COVID-19 kind of stopped, large parts of society and the economy, there were a number of funds which have become available to help the smaller organisations in Singapore keep running. So on this one, there are a few examples, and so if you are a startup, a fintech looking for support during this time, these are some of the things that may be available. In April, the MAS released a support package of over $100 million, which was really substantial and is really there to help fintechs with ongoing training, digital acceleration, and keeping their businesses going. In addition, there's an AMTD ASEAN Solidarity Fund, $50 million fund, and a fund that was set up by Razer, which is a unicorn here in Singapore. Again, a $50 million fund to help companies through COVID-19. One I just wanted to focus on and bring people's attention to is the last one on this slide, which is a fund that or a grant that is a collaboration between MAS, the Singapore Fintech Association, and AMTD, and it's the Fintech Solidarity Grant. And specifically, there are two parts to this grant. One is called the Business Sustenance Grant, and the other is the Business Growth Grant. The former is a couple of $1 million that was put aside to help fintechs, pay salaries, pay rent during COVID-19. The second is around ensuring that businesses can still grow during this time. And I wanted to focus on that second one because applications are still open for it. The first one, the funds have now been allocated, but for the Business Growth Grant, there is still opportunity. Effectively, to be eligible for this, you have to be a company registered in Singapore. You have to have activities in Singapore. You have to be a Singapore FinTech member. But in addition, for the Business Growth Grant, which I'm showing here on this slide, you have to be completing a proof of concept on the APIX platform. So APIX is the API exchange, which has been set up effectively to enable startups more easily to have proof of concepts and trials with larger organizations. So effectively to plug in your solutions to, say, a bank, so that they can see what kind of product and services you offer. The funding here is for wage support and support on technical integration to enable those proof of concepts to happen. And as you can see here, that there is funding up to 70% of those costs, and 100% of internship funding where you run a POC on Apex. So I would encourage people in Singapore who are in startups. We know that it's a difficult time right now. There are still growth opportunities. There's lots of business to be done, and we hope these funds and I guess the access to these grants gives some help to those of you who have found difficulty with business. So that's all I really wanted to say, and I'm conscious that's a little bit kind of off topic in terms of mediation. I'll pass it back to the main speakers now, I think to wrap up or take any questions that may have come through.
Thank you, Adrian. So I do have a few questions here, starting off with some questions on mediation for you, Franca. So what happens if we cannot reach an agreement in mediation? Would then the whole mediation have been a waste of time?
Okay. Sometimes it can happen that no matter how much the parties try, they can't reach a resolution. What we try and do is see which issues can be resolved, and the ones that can be resolved can form the part of an amicable agreement. We have various techniques that we use when there's what we call an impasse. And we try to impress upon the parties that if they don't reach a resolution, then, what are the alternatives to the mediation? And sometimes when they start, exploring the fact that they have to go to litigation and the cost of litigation, then at that point in time, they may come back and actually resolve the unresolved issues. But to answer the question, if really there are some issues that are not resolved, then the settlement agreement would be on those that are, and the ones that are not resolved, maybe the parties will go to arbitration or even litigation. In addition to that, I would add that all is not lost, because during a mediation, you also obtain a lot of valuable information. So even if you don't come to a resolution, you will have learned what's really important to the other side. You will have had an opportunity to express your point of view in a very safe and in a very safe environment and on a without prejudice basis. So you also gain a lot of information. So there are a number of reasons why mediation is not, lost,
Right.
even if there's no resolution.
Okay. Can the mediator propose solutions to us?
Okay, is that for me again, Catherine?
Yeah, sorry. These questions now for you, Franca, and I have a few afterwards for Chiara.
Okay. So the question was, can the mediator propose solutions? The job of a mediator is not to resolve the matter for the parties. It's to guide and help the parties reach a resolution. Sometimes a mediator can say things like, in past cases when this problem has arisen, parties have considered these options. Can present them in a very neutral way as possible options, give the parties ideas. But no, it's not the job of the mediator to resolve the issue.
Can the mediator also provide legal advice if they're also a lawyer?
Right.
We really need lawyers if we are mediating.
Okay. So let me answer the first part of that. A mediator typically does not provide legal advice. There is a method of mediation called evaluative mediation, where a mediator can tell you what the law says on a certain thing, giving you generic, this is what the law says. And the mediator also has to be careful that if he or she says that to one party, he or she also has to share that information with another party. But a mediator wouldn't sit there and apply the law to that particular problem and come up with a resolution. So sometimes sharing what the state of the law is done under evaluative mediation. On the question of needing a lawyer there or not, again, as I said in my presentation, it depends on the parties. Some parties seek legal advice in advance, and so they come very confident to the mediation, and they, in order to save costs mainly, they won't have their lawyers with them. Some of them will come without lawyers, but will ask for time if they needed to step out of the room and consult with their lawyers if they need to do so. Some of them will not have lawyers, but will want to show their agreement, the amicable agreement, to someone before they sign it. And some of them decide to come in with lawyers for the full thing. So it really depends on the parties.
And a final question for you, Franca. So once we reach an agreement in mediation, how can we be sure that parties will abide by the agreement?
Right. Well, firstly, mediation is voluntary. So if the parties are truly willing to resolve their issue through mediation, there's also a willingness that they're going to comply. Because no one made them come to the mediation. So if at the end of the day they reach an agreement which they have participated in coming to, the chances of them complying with that agreement are quite high. In the event that they don't respect the agreement, then as I mentioned in the presentation, the agreement has the force of a private contract. So you can, you can sue for damages for breach of contract. You can also apply to have it enforced. And now with the Singapore Convention on Mediation, if the country where the parties, or the countries where the parties are parties to that convention, you can easily apply to the courts to have the settlement agreement enforced.
Okay, thank you, Franca. I have a few questions for you as well, Chiara. Hi.
Sure.
So, one question coming here. Can mediation and arbitration take place via teleconference or video conference? And I think Franca touched a little bit on this for mediation, but perhaps for WIPO? How are you doing it?
Absolutely. So actually, we've also done it in the past, but even now we see it happening more and more often. And either actually a video conference, but sometimes even just telephone. So that's also an option. And I think, of course, there are some limitations which are associated with the use of online tools rather than the physical presence. But it's just an option, I think, to keep in mind, because it's also a way to further contain also time and cost. So yes, you can, and so far so good for us.
Okay, thank you. So I have a commercial dispute which doesn't involve intellectual property, IP. So how can I use WIPO mediation and arbitration?
Yes, so of course we do specialize in intellectual property, and we have a panel of IP specialized mediators, arbitrators. We have some specific rules tailored for IP disputes, but any commercial dispute can be mediated, arbitrated under the WIPO rules. I actually have to say that many IP disputes, at the end of the day, the subject matter of disputes very often is of a more general commercial nature, and we have also seen an increasing number of disputes where there was actually no IP elements. So as long as there is a commercial angle, yes.
Okay, thank you. So I don't have a contract with the other party, so how can I submit my dispute to WIPO mediation?
Sure. Or also, even if you have, but you don't have a dispute resolution clause. And that was where the unilateral request for mediation that we've seen in the slides is useful. So you can just fill in the request for mediation, submit it to WIPO, and then we can assist getting the other party to consent to the mediation. And of course, requesting mediation, because the mediation has not started yet, is not subject to any fee, so that's absolutely free of charge.
Okay. Which point is it appropriate to start a mediation if you're having a dispute?
So I would say, and frankly, it would actually be very useful to hear your thoughts on this, but in our experience, I would say as soon as possible. But in any case, it's never too late. So even, for example, we would suggest mediation as a first stage, and if the mediation doesn't work, then you can go to a more formal dispute resolution process like arbitration or court litigation, but we suggest you try mediation first. We've also seen cases where, for example, parties were already involved in court proceedings, and you can still actually request for a stay of the proceedings and try and submit the dispute to mediation at that point in time. So I would say at any point in time. Of course, the earlier the better. Also because of all the time that you've spent saying in court litigation. But I think I'll be happy to hear from your experience actually.
Sure. Absolutely, Cara. I totally agree. It's best, of course, if you go to mediation from the start. But at any time during proceedings or at any time during the dispute, and in fact, if you tell the court that you need to adjourn because you want to try mediation, the court will be very happy because they are trying to encourage ADR. And so at any point during the dispute, or you can also choose certain parts of the dispute that you feel can be mediated and mediate those issues. And then if you want to continue with your other issues in court or elsewhere, you can do that as well. So it's very, very flexible.
Thank you. And one last question for you, Chiara. So how long does an average WIPO mediation take, and how much does it cost?
Okay, so of course that's very case by case, because we have a huge variety of cases ranging from cases involving multinational or pharmaceutical companies to really startups which have different types of disputes. So it's not very easy to have an average, because we also tailor the procedure, but to give you an average also based on the last cases in terms of time for mediation, I would say from the moment the request is submitted, then there is the appointment of the mediator, the scheduling the mediation within 3 or 4 months. Actually, all the last cases which have been held online, conducted online, it was actually done within a couple of months because, of course,
Okay.
much easier. But the average is, including also the physical meeting, 3 to 4 months. With online tools, how much does it cost? Again, it really depends. But on average, also thinking of the very last disputes that we have seen, which have also been international with the multiple parties to it, it was around 10,000 Singapore dollars, which is split between the two parties. How much is that? It should be around 7,000 US dollars. Correct me if I'm wrong, and that's usually split. That's split between the two parties, 50-50.
Franca, do you have anything else to add on costs?
Well, I think, you know, the costs of mediation are extremely reasonable. And in fact, sometimes I think about it and I think that mediators and the whole process add so much value, you know, to the resolution of disputes. And, you know, sometimes I feel that mediators are maybe undervalued, but the whole system is there to encourage mediation, to encourage ADR, and to help the parties as best that we can. So the cost of mediation, because mediation takes place over a short period of time, it's usually done in a day. You know, it's very, very affordable for everyone. And a mediator will often speak to the parties and see, you know, if there are budgetary constraints, to what extent he or she can help them. So actually, it's, you know, when you compare it to the alternatives and you look at the value that you're getting, it's a very, very good proposition.
Thank you. So that's all the questions we have from today. So I'd like to thank you very much to our panel, Adrian, Chiara, and Franca. Should anyone viewing have any further questions or you'd like to follow up with any of the panelists, then we'll share their email contacts now. Thank you, Margaret. And yeah, thank you everyone for joining us today, and have a pleasant evening or day ahead.
Thank you. Thank you, Catherine. Thanks, everybody.
Thank you.